Good morning and good afternoon, everyone, or good night. This is the third panel of this webinar series entitled Empowering Perspectives, Unpacking the Brazilian Industrial Property Law. I would like to thank you all for virtually coming for this webinar. In particular, I would like to thank the Young Scholars Initiative for incentivizing the organization of this event through the Finance, Law, and Economics Working Group. I also would like to thank Future Law and LAPI UFRJ. This webinar series is based on the book, as you may know, Comments on the Brazilian Industrial Property Law by Women, recently published by Thomson Reuters. Therefore, this webinar aims to bring together some of these women to talk about the IP scenario in Brazil. It is the first time that we had such a piece of work authored and organized by women in Brazil and maybe in the world. And therefore, it is also the first time that a webinar series is exploring and following this path. Today, we are going to discuss competition and innovation settings, a discussion that is vital for economic growth. And the title of the panel is How to Defend and Incentivize Innovation at the Same Time, discussing IP infringements and solutions in Brazil. I'm Deborah. I am an IP and competition lawyer. I have a Master of Laws in Economic Analysis of Innovation and Intellectual Property at the Universities of Hamburg, Ghent, and Pompeu Fabra. And together with me, also moderating this panel, we have Ana Carolina de Azevedo. Ana, would you like to introduce yourself?
Yes, thank you, Deborah. Thank you for everyone that's listening to us. So I'm Ana Carolina. I'm a trademark attorney at Guzman Lambrini. I am also a Bachelor of Laws from the University of São Paulo, and I have completed an extension course at the University of Bologna, Italy. I am also a postgraduate degree in intellectual property and new technologies at Getúlio Vargas Foundation, and I'm a member of the Fashion Law Commission from OAB Campinas. Thank you, Deborah. Now she's going to present us the agenda for today.
Thank you, Ana. Yes, so today we have two expositions. It will be 15 minutes each. And then with the remaining time, we'll have time for discussion. So please feel free to write down your questions. Meanwhile, we are here exposing, so then we can read them timely. That said, I would like to introduce to you the first speaker of the day. Her name is Aline Ferreira de Carvalho da Silva. She's a senior lawyer and she holds a LLM in IP from Cambridge University and actively takes part in lots of Brazilian IP associations. So Aline, the floor is yours. Thank you very much.
Thank you very much, Deborah, and thank very much the Young Scholars Initiative for having us today. And I have a short presentation. I will start to share screen. So can you see the presentation?
Yes, we can see.
Okay, I guess it's not in presentation notes.
Not yet.
Now it's okay. So this presentation just to help us to go through the topics because I have very little time, lots of things to talk about. And to begin with, as Deborah told you, I'm an attorney. I have been an attorney for roughly 15 years.
Aline, I'm so sorry to interrupt you, but I am still seeing the PowerPoint, not the presentation mode. You guys are seeing the presentation mode?
Okay, so I'll stop share. And then begin again. Oops. Sometimes it happens. Sometimes Zoom does not work as it should. But let's try again. No. Well, can you see?
Now we are still seeing the PowerPoint, but if it doesn't work, we can follow this way. For me, it's like we can follow the, yeah, now it's working.
Okay.
Yes, perfect.
So I have been working in this field for roughly 15 years, and as a lawyer, mostly focused on patents. And that's why probably I was invited to write about the crimes against patents and industrial designs in the Brazilian Intellectual Property Act. And I'll begin my presentation by talking about the general, giving you a general overview on how the Brazilian law established the conducts related to crimes against patents and industrial designs. First of all, as you probably know, the TRIPS agreement has an obligation to have member states punishing as criminal offense both copyright infringement and trademark infringement. But that's not the case for patent infringement and industrial designs infringement. And why the Brazilian legislator, the lawmakers, decided to make those conducts a crime. That's something that's in the Brazilian tradition and has to do with the understanding that if you make something a crime, then you dissimulate, you deter that conduct. But in the reality, unfortunately, the thing is that very few patents and industrial design infringements are prosecuted in Brazil as crimes. And why that? First of all, the punishment, the penalties are very low. And according to the Brazilian criminal proceedings law, the prosecutors may have plea bargain with defenders. So most of the cases and the few cases that are brought to criminal justice, they end as in an agreement with the prosecutors. The second thing is that the Brazilian police, they are not properly equipped to deal with patents and industrial designs infringement. In Brazil, the police, we have 27 states, and each state has its own police. And each state has a kind of an institute that's in charge of doing the forensics of crimes. And in most states, these forensics institutes, they have few money, and that the few money they have is usually directed to solve other crimes like murder and racketeering and the like, not exactly IP infringement, especially because the penalties are so low. And also, Brazil is a young country, and despite having intellectual property laws since the 19th century, the truth is that people do not have a good general knowledge on IP and its importance. So this sort of crime is not seen as a priority in a scenario where you have lack of resources. And also, I have to say that in Brazil, these crimes can only be prosecuted if the victim, there is the companies, starts the proceedings. And sometimes it's very expensive to do that with little perspective of have an effective result. So that's also a choice in this case. But while we're talking about patent infringement and industrial design infringement as a crime, if the scenario is so, how can I say, lean, that's because there are many conducts that are listed as crimes that are not listed in the chapter of the law that deals with civil offense. So, to fully understand the scope of a patent and what a patentee or a digital design holder can do, I have to read the chapter of criminal offenses jointly with the patent chapter and the industrial design chapter. And when I'm talking about patents specifically, there are two specific provisions that are key for holders, for owners, that are the provisions on the doctrines of equivalence and contributory infringement. According to the law, these two provisions also apply to industrial designs, but it's very difficult in reality to put that into practice, and I will explain later why. But as for patents, these two provisions are key because there are known provisions on these two topics in the civil chapter. So in Brazil, we have Article 108.6, that is the one that deals with the doctrines of equivalence. And it just says in a nutshell that that's not just the literal infringement of the claims that is deemed to be an infringement of a patent. But the thing is that this provision does not explain how to assess the doctrines of equivalence in Brazil, which tests we should apply, and how. And that's one thing that makes sometimes difficult to explain to courts that there is an actual infringement despite not having a literal infringement of the claims. In Brazil, there's a very famous author called Gama Cerqueira. And Gama Cerqueira wrote in the first half of the 20th century. So having another wording, another law, another constitution, or a completely different scenario, okay? And so, according to Gama Cerqueira, to assess equivalence, one should consider the idea behind the invention. But the thing is that, as you know, intellectual property is not aimed at protecting ideas, but rather solutions, creations, not things in abstract. While I do have lots of respect towards Gama Cerqueira, he's simply wrong. And that's dangerous because we're talking about criminal offense. And as you know, criminal offense must be written in a sharp way so that if I'm in doubt, I have to consider that there is no crime because we have the principle in dubio pro reo, which is very old, that comes from the Romans. And actually, what happens is that the Brazilian scholars are the ones that have studied the most how to deal with equivalence in Brazil. And they generally tend to reflect what's being discussed in the US and in Europe. They discuss like very old authors. I'm not talking about 20th century authors, but rather Kohler, who is a German scholar from the 19th century. He was the first to bring this doctrine in Germany, but not in the world. As you probably know, the first court to apply the doctrine of equivalence was the US Supreme Court. That's why we have a very hesitating case law in Brazil when it comes to the doctrine of equivalence, because people have to rely in foreign scholars that probably not the most up-to-date scholars on this subject. So based on some discussions that we have been having in Brazilian courts in the last years, I suggest in my article that the first thing that we have to consider when assessing equivalence is how to construe the claims. And then we can apply the tests. And we also have to consider what was already in public domain. And when you have a public domain that's full of prior art, the room for equivalence is very small. But when we're talking about disruptive inventions, that's a different thing. And then we do have a larger room for equivalence. And when it comes to contributory infringements, the thing is that we have very few case law in Brazil. And also, the provision is very laconic. And it may open the room for someone to construe contributory infringement as an act of inducement, which is not the case. If you study the civil and criminal offense together, you have to come to the conclusion that when you talk about the criminal provisions on contributory infringement, you are talking about the provision of elements for someone else to do the actual infringement. Okay, but sometimes the elements that we are providing the third party with is something that's not covered by the patent or the industrial design. So that's why you have to consider that you only have contributory infringement if the person who is contributing with the infringement has the knowledge that this very element will be used for infringement. And at last, in Brazil, the patent office does not actually assess the merits of industrial design applications. So they just take a look if the formalities were met, and that's it. You only have an assessment on the merits if the applicant asks the patent office to do so. Sometimes the Brazilian patent office grants industrial design registrations that do not have any merits at all. They do not have any sort of originality. They cover technical aspects of an object. They do not meet the minimal legal requirements to be industrial design, and that can be a problem when you are assessing infringement, especially because, unlike it happens with patents, we do not have claims, we just have the drawings. And it's an analysis that's very subjective sometimes. And because of that, I propose that before assessing any actual infringement, you have to have a search on the prior art to understand whether it's the registration actually deserves, has actually any merits. And I was assigned very little time, and because of that, I do apologize. And if I have spoken in quick speech, but then we have some time for discussions, and you are very welcome to ask questions. Thank you very much.
Thank you very much, Aline. I'm looking forward to discuss right after Pietra's exposition. And following the agenda, Anna, would you like to introduce Pietra? I think we can't hear you.
I'm sorry, this always
No, we
happens, so it's my time today. I would like to introduce you the second speaker, but before that, I want also to congratulate Aline for her clear and interesting speech. And so it was very nice, and we will have the opportunity to discuss this later. Regarding Pietra, our second speaker, she's a PhD candidate at the University of São Paulo and Pantheon Sorbonne. She's also a researcher at Sorbonne Institute of Legal Research, a member at the Tech Law Committee at the São Paulo Institute of Lawyers, professor at Campus Sales College, and senior associate at Mansur Murad. So please, Pietra, the floor is all yours.
Thank you, Anna. Thank you, Deborah, for organizing it. It will be a challenge to say after Aline. Well, I'm going to share my screen with you. Where should I do it? Okay, share screen. It's easy, actually. Okay, can you see it?
Yes.
No? Okay, perfect. Well, so I had the opportunity to co-author an article with Juliana Domingues and Ana Cristina, and we talked about how policy initiatives, how legal framework and collaborative efforts are being used in Brazil to combat intellectual property powers in our country, because we know we as a country, we have been actually addressing the issue, and with e-commerce, the numbers of powers have increased, and we have a lot of cases related to disinformation, misinformation, and a lack of education where people don't know when they are buying something related to piracy or not. And the losses were around third, actually. Oh my God, I'm sorry. my mind, I just arrived from France. My mind is thinking in French, you know. It's around 300 billion in illegal markets. So this number have increased a lot in the last years. We know that in 2014, the number was 3 times less than it was in two years ago. Well, starting to talk about our article, we know that piracy can cause moral and financial damage, and it can prejudice also victims on the owner of the trademark, or the inventor of the patent, or the author of some overage, and our society at the same time. And Brazil has established a legal framework to combat intellectual property crimes. Our paper focused on trademarks infringement, and we analyzed and we did a criminal analysis of the Article 189 of industrial property law. Well, to talk about the legal framework and criminalization, as Aline said about patents, The legal action against trademark violations requires a private complaint by the victim. It can also cost a lot for the victim, and the penalties can include also imprisonment and fines. But actually, we have a difference here. We can suit someone in the civil sphere and the same time in the criminal one. And in the criminal one, it's gonna be in the special criminal courts because of the minor nature of these offenses. And we know that, talking about Anna, who is the author of the article, who is specialized in criminal law, she talked about the measures that are related to the law 9099, that is the law for minor nature offenses. And she explained that actually we have diversified measures, and that's the reason why the scenario has to be seen as how can I say that? It has to be seen in a package, as we can, if I can say in the same way, in this way, because we have other measures that can be combined with the criminals one. And we have, for example, inspection, seizure, the destruction, fines at the same time as criminal measures to combat this kind of violations. We have a difference here in when we have an exception, actually, when we have a coat of arms, official emblems, insignias, we don't need a private complaint because they are related to the state, to the union. So we can have the federal one. We don't need to start it. The company doesn't need to start it. The victim doesn't need to start it, because we can say that the victim is our society in general. So that's the reason why we have this difference. Well, that's what I was saying. Actually, the Article 189 cannot be seen isolated, because in most cases it serves as a starting point for other criminal offenses. And for example, even if this article, this criminal article, it has fines that are not really big, or the imprisonment that is not really, how can I say that, really something that is really problematic, we know that, for example, a trademark violation can be the starting point for other kind of violations, for example, frauds, tax evasion, money laundering. And that's the reason why the criminal measures can be bigger and can be also important to take care of the subject, because these behaviors, they represent a higher offense potential. And for this reason, we can have a higher criminal penalties too. For example, I gave here the example of the money laundering under the law 9613 from 98, and we have here 3 years of imprisonment for example, at minimum going to 10. And to talk about the battle against piracy in Brazil, I had the opportunity to write with Juliana, who was conducting the Senacom projects in that moment. Senacom is our Secretary of Consumer in Brazil. And we saw that Brazil was employing a multifaceted approach to combat piracy with governmental policies, international partnerships, private initiatives, and social engagement. And few of them are here. For example, in 2003, we had the CPI on piracy. After that, we have the Council to Combat Piracy, National Council to Combat Piracy in Brazil. And after that, some specialized commissions were created, and one of them was responsible to publish the National Plan to Combat Piracy, Smuggling, Tax Evasion, resulting from then and crimes against intellectual property. And this plan, they are going to take place since last year. Actually, it started to take in place since last year, and it's going to finish in 2025. It has actually four spheres of action, and for example, educational one, the adequacy, another one is the adequacy, the governmental policies. So we know that we have a multidisciplinary approach in this plan to have different actors from the society dealing with the subject at the same time, which is very important, as we know, because we need the action from different people at the same time to deal with a problem that can I don't know, to achieve everyone in our society. We have here an example that is the Operation 414 against digital piracy. It started with illegal streaming and the boxes TVs, and it have already happened in different phases. So the Operation 414 was really important in some cases, even during the pandemic time that we faced, and it's still happening. We are now in the 60th phase. We have also, we published also a good practice guide for e-commerce platforms, and it was governmental with private sector at the same time to deal and to face the pirates in digital platforms. Senacons, that is the secretary that I told about, had an important campaign against piracy vaccines, because during the pandemic here, in Brazil, we faced this problem, misinformation, disinformation, piracy products together at the same time, and we had a biggest challenge that was the health in this moment that was not easy for anyone here. And we have also collaborations like anti-piracy, Rede Anti-Pirataria in Brazil with the United Kingdom that demonstrate effective partnerships. In the civil domain, we know that, we talked also about in the criminal sphere. Now we talked about some policy initiatives, and we are going to talk about how trademarks violations are dealt in the civil domain. And here in Brazil, we have specialized courts and judicial chambers designated to handle disputes concerning intellectual property, and that's important because it's really important that the judge will understand the problem and to have the right tools to deal with the matter. So we also have an understanding that now if you have intellectual property infringement, we have the moral damage is deemed in re ipsa, signifying that it is self-evident or intrinsic to the action itself. And to finish, the future challenges and conclude remarks is that we need to deal together with this kind of problems, and the international cooperation is really important because now we are facing a digital moment, a digital environment where we don't have barriers, we have actually e-commerce platforms that are coming from China, from United States, from I don't know, a lot of different countries, and we have also judicial complexities that has to be dealt by people who are specialized in the subject. That's the reason why we need specialized lawyers too. And we have also few initiatives, governmental initiatives, but it's really important that we have education, society education in this subject, because if we don't have, we need to do actually a pact with protecting laws, regulatory, environmental incentives in research and development, education, innovative hubs, and infrastructure development to create an environment that protects IP and encourages a continuous cycle of innovation, ensuring the sustained growth of economies and industries. That was what That was what we conclude in our article, because we had the opportunity to talk between someone who was in the government in that time dealing with this kind of problems, Ana Cristina, who was specialized in criminal spheres. I was specialized in IP, subject in the civil domain, so we could understand that the multidisciplinary approach is really important. We need to deal with different actors. We need to work together to construct a better environment. And even in this moment that is difficult, because we have the internet coming with more challenges for us. So that's what I'd like to say. I'm so sorry for the mistakes here, and thank you, Ana and Deborah, again, and congratulations, Aline, for your presentation.
Thank you very much, Pietra. It was a lovely presentation, and if anyone has questions, please, this is the time to ask. And I would like to Aline, do you want to say something?
Yes, just to have a quick conclusion from both panels, from both subjects. The thing is that generally criminal offenses are prosecuted when they related to crimes where the penalty is higher. And that's true also for patents, because as I told you, patent infringements themselves are generally not prosecuted, but when we are talking about public health, sometimes Anvisa, which is the Brazilian Food and Drug Agency, it's similar to the American FDA and the European EMA, is having an investigation on fake drugs and fake supplements, and they come across also with patent infringement. But the case is prosecuted not because the patent infringement, but rather because the crime against public health, which has a much higher penalty than the patent infringement. And that's true not just for the vaccines that Pietra mentioned, but also, as you probably know, that one of this year trends was semaglutide, a pen used initially for diabetes, and people are now using to lose weight. And in many countries, and Brazil is not different, there are people selling fake pens, and that do not have actually semaglutide, but rather another thing that we don't know what is. So these cases are prosecuted not because of the patent infringement, but rather because of the crime against public health. And it's important to stress that Anvisa has very high standards when it comes to drug quality. Anvisa is part of the ICH, like the FDA and EMA, and they have agreements with Mercado Livre and other Brazilian marketplace. And sometimes before even start a court case, they are able to have an agreement with those marketplace, and to take down the ads and then put these fake drugs out of the market. So just that.
Thank you, Aline. And I would like to follow up now. I would like to go back to the equivalence theory, if I can, because it's a very complicated topic, I would say. And I would like to ask you, Aline, according to you, what would be specifically the competitive consequences regarding what we face now in Brazil when we talk about the equivalence theory for patents and industrial designs? For instance, what do the corporate governance and the IP and innovation management divisions of a company should be ready to face when we are talking about Brazil?
Because the law provisions are so laconic, and we do not have specialized courts across the country, we just have specialized courts in few states, Brazilian states. We have in Rio, São Paulo, Minas Gerais, Rio Grande do Sul, and when it comes to federal courts, we just have specialization in Rio. So the thing is that because judges do not study intellectual property in law schools, they tend to put much weight on the expert evidence reports that are made by the expert they appoint. And generally, those experts who are chemists, engineers, and the like, they are not familiar with IP as well. So the first thing companies should do, and I know lots of associations do that, is to educate judges and experts and fight for having specialized courts. And also, they should consider that because the law provisions are so laconic, sometimes the experts and the judges may interpret as equivalent means things that are not equivalent means, because they were already in the public domain. They were known to someone skilled in the art prior to the patent or the industrial design. So sometimes before launching a new product, we have to have a strategy considering that may happen. And before being sued, you have to sue first. Sometimes you have to file a declaratory lawsuit just to say that I'm not infringing anything, because that was already in the public domain. And have the control of the narrative. That's something that companies should consider. And that's bad for competition, because not every company is in a position to have the resources to sue first, or to sue a multinational company that has been exploiting a very attractive technology for years and years and does not want to lose the monopoly. So that's one thing that should consider, and that involves certainly competition.
Thank you very much, Aline. As we can see, there are a lot of to think about in this topic in Brazil. Otherwise, we might create a destructive market in our own market. Well, if anyone have any other question, Ana, do you have any question?
Yes, I want to firstly thank you, Pietra, for your comprehensive overview, and also say that the data that you shared with us, they were very interesting, and also showed Brazil's efforts in combating piracy. And you mentioned about Operation 404, and we know that it had several phases. And while we were speaking, it came to my mind that there was one phase recently in November, and that it involved other countries. So do you know more details about it? Did it have a specific goal?
Yes, thanks, Anna, for your question. Actually, in 28th of November, I think we have the 65th phase of the 404 operation related to the illegal streaming of the English Championship, and it was done with other countries, so Argentina, Peru, United States, and UK also helped Brazil, and they were also analyzing the infringements related to their own law. So we had this phase last 2 weeks ago because of the English Championship, where there were some illegal streaming in the countries.
Thank you. And I think that's also worth mentioning, as you were discussing about how the state is creating some kind of measures to combat the piracy. It came to my mind that it's also important to talk about the private sector, because even though we need to create these multifactorial tasks, and this involves education and also hubs and so on, the private sector, I believe that this is also creating a relevant role in this paper. And as Aline also mentioned, we have Mercado Livre and another great and big marketplaces here in Brazil that they are developing their own brand protection programs. And I believe that they are very important for us also to combat piracy and other types of crimes that are related to it, because we know that with the internet and the pandemic, the growth of the e-commerce, it's very expressive. And now if we have the private sector aligned with the government, we could create a more comprehensive strategy to combat this and also have results. Mercado Livre, they like to show their results because they are also very impressive. And I believe that we are in a good way, and also in comparison to other countries. Brazil is very worried about the situation and trying to create some policies to cover it.
Yeah, I totally agree with you. I think the corporative governance is really important. And these measures, for example, Americana, Magalu, and Mercado Livre, they have this kind of brand protection programs that are really effective. And they relieve the justice, because the judiciary, because it's impossible to manage all this kind of issues in the judiciary with in the time that we need, with the effectivity that we have to deal. So I agree with you that these programs, they are really important and they are incentivized by the government, and that's the reason also why we need the corporative governance, incentivize the research, the development of new tools, of innovation, of new products, and also to have some open innovation, collaboration, to talk between the markets, to understand what are the initiatives that work well with some and that doesn't. Intellectual property management, that I think it's related to this kind of brand protection programs, because nowadays we know that we have few softwares that can help companies to analyze and to identify if this kind of products, if their trademarks are being violated or not in these digital platforms. But they have also few challenges to face. So it's important to have intellectual property management, and to know that you can count on legal advisors to understand what are the limits or not, because we know that our law, it has few points that actually they can say, oh, this is not an infringement, this is an infringement, this is only description of the product. So it's important to understand this kind of limits too with advisement. And we also talked another day about talent management, to attract and to retain talents in the companies, to create new products, and to understand how the environment, the innovative environments can grow and can prosper in this kind of companies in our country, etc. So I think it's really important to have both kinds, actually three important actors here. So we have the corporate governance of private companies, we have policy initiatives, but they are few. So I don't think we need to say that it's only their problem. So we need to face together this problem, and the society also needs to understand the problem, and to have the incentives to deal with it, to face it, and to consume the right products, and to help companies to, I don't know, to create a good environment in the society at all. So I think it's important to have all the actors and these spheres at the same time.
I would like to take this link that Anna and Petra just opened and ask Aline's opinion, especially on open innovation. Because I mean, sometimes the open innovation doctrine, it seems in contrast with the IP doctrine, let's put this way. But in the end of the day, as Pietra was saying, it will depend pretty much on the corporate decision and how the lawyer and also the economists, experts on this regard, interpreted each advantage and disadvantage of each one. So, for instance, in Italy, I know that in the past years, they face a very great experiment, especially in the company Enel, when they promoted open innovation ecosystem with different partners in Italy and also abroad. Another example would be that in 2014, Elon Musk, the CEO of Tesla, decided to open its patents to everyone. And which means that since then, everyone could use Tesla's patents to produce electric vehicles and so on. So, Aline, according to your experience, do we have room in Brazil for companies to employ an open innovation ecosystem, and how can that work in practice here?
And so I do believe that open innovation and IP are not rivals, okay? Because IP is just a strategy to retain value from something that was created, but it's not the only strategy. You can create value by other means, and you can start a project as an open innovation project, and then have IP from a specific part of such project. That's also possible. And sometimes it's interesting to have open innovation in a field where the stakes are high, but the investments should be high as well. And it's better to share risks with other players and to collaborate rather than have like just a private research. And also, sometimes you'd better have like cross licensing instead of just having one player like having the monopoly of the markets. And also open innovation helps companies to have a quicker pipeline of innovation, and that can be key in some markets like IT and telecommunications in general. So what you see is that telecommunications and IT, you see a growing number of cross-licensing and open innovation, because companies want to further their research in a quicker pace. And also they want to avoid problems when entering the market, because other players also have their own patents for specific parts of the technology. And in the pharmaceutical field, which is the field I have most familiarity, what happens sometimes is that we have long pipelines, because we have the clinical trials and everything, the regulatory burden. And what happens that the early phases of innovation begin with public money. So it's open innovation. But then, because we have to take risks and pay large sums to have the clinical trials, then we have like a private company sort of buying the research, and then IP comes. So we have like the early phases as an open innovation, but then when you are about to launch the project, then you have IP for things like the formulation and the delivery of the drug, because it's sometimes the failure or the success of a project lies on the way the drug is delivered. Generally, people prefer to take pills instead of taking shots. So if you're able to deliver a drug by means of a pill, you are likely to have more success instead of using a shot. Semaglutide was something that was like a black swan, because it was a highly successful drug using a pen that needs to be put in the fridge. But that's because it was what we call in pharmaceuticals a long unmet target. That was a pharmaceutical target that had no competitors at that point. So, but it's not the regular scenario. So I think there is room for both. And it depends also on the industry.
Thank you, Aline. Thank you very much. Well, I wish we had more time to discuss all this subject to how to incentivize and pursue innovation. But unfortunately, it's time to close the panel now. And I would like to thank you all very much for attending. And especially, I would like to thank Aline, Pietra, and Ana Carolina for joining me today in the session. Thank you very much. I hope to see you all tomorrow for the last panel of this webinar series. Bye-bye.
Bye. Thank you very much.
Thank you, Deborah. Thank you, Ana. Thank you, Aline. It was a pleasure to be with you tonight, to this morning.
Bye-bye.
Bye. Thank you.
Bye-bye.
Bye.